SJC-13645, Commonwealth versus Louis C. Cabrera.
Okay, Attorney LeClaire.
Good morning, Chief Justice Budd, and may it please the court, Jessica LeClaire for Louis Cabrera. This case is about finality. At a certain point, a judicial officer's decision must be deemed final and binding on the parties, especially where that decision has the effect of terminating a prosecution. In this case, where the Commonwealth did not seek judicial redetermination of that first magistrate's decision, did not seek a 211-3 petition, did not resubmit that complaint with new evidence, or ask the first magistrate to reconsider his interpretation of the statute, and offered no explanation for the close to 3-year delay before refiling a second application for complaint, we are long past the point of finality. And it is our position that that first magistrate's decision is now final.
Do you have case law for that? Sorry. Do you have case law for that? Do you have, what do you have to offer?
This is a unique situation, but I would point the court to Commonwealth v. Williams, where and that's 431 Mass 71, it's cited in my brief, where the court said that where the Commonwealth failed to take steps to seek judicial review of a decision denying a motion to suppress, and instead dismissed the case and then refiled for an indictment, that decision was final because the Commonwealth had an opportunity to review the decision and chose not to.
Counsel, assume for the sake of argument that they could have taken an appeal to a judge. If you're within the statute of limitations, you don't suggest that if a grand jury no-bills a case that the Commonwealth can't represent to the grand jury, do you?
No, Your Honor.
So how would this fit within that if there's no probable cause and a magistrate looks at it this time around? And I understand that there was an intermediate step that they could take. Why can't they just go back in with another application if it's within the statute of limitations?
The reason is, first of all, the statute of limitations serves a different interest.
It does, but I'm just saying, if you're not outside of the statute of limitations, why can't they just go back in like they did? If you can go back in and re-indict or re-present to the grand jury, why should this be any different than that?
The reason is that if you do that, then you're endorsing what happened here, which is rendering that first magistrate's decision essentially optional. And we want the collateral estoppel doctrine serves the interests of reliance on adjudication. We want the legislature says this is a judicial officer who is vested with discretion and they're required to make an initial determination of probable cause that will either terminate the prosecution or allow it to proceed. And we want the parties to obey that decision and follow the...
Could the DA have indicted the case?
We do not dispute that the Commonwealth could have sought an indictment.
Okay,
and
then
so
how is it final?
the decision by the magistrate finding no probable cause is final. The Commonwealth could have indicted...
Let's talk about the word final. You agree that the magistrate finds no probable cause, right? And there's no appeal. You say it's final. You also agree that the DA could have said, okay, we're going to go to the grand jury and we're going to indict for the exact same offense, and the person would be hauled into Superior Court and arraigned. Where's the finality?
The finality is because the Commonwealth didn't do that, first of all. But second, they had an...
Well, I'm asking you about the finality of the magistrate's decision where you concede that the case could continue as a Superior Court case.
I think that I would concede that it could have continued within a reasonable time, whether...
Be in the statute of limitations.
But my client's interest in finality...
I'm not saying this wasn't harsh. The question is whether it's precluded by collateral estoppel. Collateral estoppel requires finality, and as I'm hearing your argument and you concede that the case could have been indicted, I'm not getting finality from this.
Well, the grand jury is an independent body, that it's not a judicial body, and so that grand jury, the Commonwealth could have presented this to a grand jury. Whether that grand jury would have indicted, we don't know. But we have a magistrate, a judicial officer who did make a decision. We have a
So the
legal.
judicial officer's decision is not final for purposes of the grand jury, but it is final for purposes of refiling in that same court?
Yes.
Where is that? What's the legal authority for that proposition, that finality would be determined on whether you go back to the same clerk magistrate or a new grand jury, separate path?
I think the finality comes in because
No, what's the legal authority for your position, that a decision can be final in one context, but not in another, where it's the same party, same issue?
I would point the court again to Commonwealth v. Williams, where they said the decision was final because the Commonwealth did not pursue judicial review in the proper forum.
When you talk about a judicial determination at the inception of no probable cause, what about the old-fashioned probable cause hearing, right? So back in the old days, they used to have probable cause hearings. Probable cause hearing, a district court judge says no probable cause. Does that preclude the Commonwealth from going to the grand jury and seeking an indictment?
No, no. So the Commonwealth, the part of the Commonwealth's interests aren't really harmed by a ruling in my client's favor but what we want to impress on is reliance on adjudication. We don't want the Commonwealth.
I'm not saying they did a good job, and I'm not saying it's not harsh. The question is, was barred by collateral estoppel.
And I think that the reason it's
There's
barred is
no
because.
attaboy to counsel over there. They should have appealed.
Right, and if they don't appeal, then there's no reason why they would need to go to a grand jury. They can just keep presenting this to a different magistrate. We have a concern about forum shopping in essence. In other words, let's say that they did have a show cause hearing. The magistrate denied probable cause.
The magistrate in this case was legally wrong about an element, correct?
I would agree that I raised the question of whether there was legal, whether there was probable cause. I think it's ambiguous, and the rule of lenity may entitle my client to relief if this case were to proceed to a direct appeal on that question. But I think the Commonwealth could have asked that magistrate to reconsider their interpretation of the statute.
Sorry, excuse me, just are you, collateral estoppel only applies where an issue was necessarily decided in the prior proceeding. So on the basis of the record before us, what is your position as to what we know was necessarily decided, and particularly what, if any, factual issue was necessarily decided?
The factual issue decided in our position is that the magistrate looked at the facts alleged by the Commonwealth, which was my client was on his porch with a firearm and appeared to be under the influence. And those factual circumstances did not satisfy the elements of the 10H statute that he was charged with. So that would be the factual application of the legal standard to those facts, and that was what was decided. And once that magistrate made that decision, yes, the Commonwealth could have, they could go to the grand jury, but they could also appeal, and there's rules that say they have to seek judicial review. We do not want a system where.
May I ask you about that last statement? So I don't know which rules you're referring to that say that mandates further judicial review. I see the complaint standard that you put in your addendum. It didn't look like that was a mandatory requirement. Am I correct?
Yes, I misspoke.
And also,
Yeah.
right, and 211.3 is not mandatory, right? It's not mandatory to seek 211.3 review. And my question is, with respect to either of those, is there a time limit for seeking redetermination by a judge under the complaint standard rules?
I believe the complaint standards say, or suggest a reasonable time for
But
seeking judicial.
do they have a deadline?
But there's no,
Is there a deadline on 211.3?
I'm not aware of a deadline on 211.3
Right, so
either.
if there's no deadline, then what weight can we give to the fact that they didn't seek, or they haven't yet sought, review under either of those mechanisms? I mean, in terms of determining whether the clerk magistrate's determination was final.
So our position is that they have to seek review within a reasonable amount of time, and because the defendant has an interest in the finality of the decision. The defendant
That's
is
usually
there,
why we have a statute of limitations, no?
but the statute of limitations serves a different interest. The interest served by the statute of limitations is we don't want somebody charged with a crime. We don't want this delay before they initiate a prosecution. But here we have a prosecution was already initiated. We have a judge or a judicial officer who said, we're done here. You can go home. You're not charged with a crime. My client has an interest in that decision. That to him, he reasonably believed that magistrate was correct that the litigation had terminated. The legislature in 218 section 35 says 1 year after a magistrate denies, says there's no probable cause, we are going to destroy the records of that application for complaint. And that's because it's to protect the accused from having these public documents available when there's really hasn't been that legal standard satisfied. And so that would suggest that after 1 year, the defendant is entitled to rely on that judicial decision. And if the Commonwealth doesn't take some action within that period of time, then the defendant's interest in the finality of that decision has essentially vested or crystallized. And this court speaks to that concept in Commonwealth v. Salafka, where there was an illegal sentence, and it's similar to the suggestion here that maybe this magistrate made...
But he served, at Salafka, they served the illegal sentence.
And the probation period started, and it was after 1 year that the Commonwealth wanted to impose GPS, and what this court said is, that finality interest is vested. And even
the
though
finality in Salafka, in the cases that follow Salafka, had to do with imposition of a sentence, much different than non-charges, right?
I understand it's different, but the doctrine of collateral estoppel does protect that same interest, the defendant's interest in finality, the defendant's interest in relying on...
Which assumes it's the final judgment. That's the problem. It's a chicken and egg issue. It assumes finality in your answer, right?
Go ahead. No. Do you want to just...
I'm sorry. I apologize.
No, I was going to move along to the due process issue, so...
There's one other issue with the collateral estoppel, if I could, before we move on. So one of the things that we talk about with the finality, but it's also what is final. And when we're talking about collateral estoppel, you're talking about an ultimate fact that was determined. That isn't that, right? A probable cause determination, how does that fit when they're not making a determination on the merits of the underlying complaint? It's just probable cause.
Well, I think collateral estoppel has historically been given broad application, and so you could say the same of a motion to suppress. A judge is deciding whether this legal standard has been satisfied by applying that legal standard to facts. And so the magistrate at that first hearing is making what would be called a mixed question of fact and law, looking at the facts that are alleged in the police report, assuming those facts are true, and then asking whether they satisfy the elements. So we do think there's a factual question there that's being resolved. And in fact, that decision is ultimately what decides whether the prosecution will go forward or not. So historically, there hasn't been these carve-outs to the doctrine of collateral estoppel as to any particular proceeding. It applies broadly. It does have stringent requirements to satisfy it and to win, but I do think it applies to all stages of the criminal proceeding.
Counsel, what is the rationale, if you know, for our jurisprudence that allows, in the context of what Justice Gaziano was talking about, the old probable cause hearings, allows the prosecution, if it fails to meet probable cause at the district court, to then refile to convene a grand jury. What's the rationale behind that?
Well, I think the rationale is that if they're invested in the prosecution, there's possibility of wanting to proceed. The grand jury is a check on the prosecution, but the Commonwealth has the opportunity to error correct the district court's denial of probable cause, but they also have the discretion to seek an indictment if this is a serious offense that they think there was an error. So so the rationale is they have extraordinary discretion in this area. And I think that the rationale for allowing a grand jury to make a second presentment to a grand jury is that there's no opportunity for an appeal when a grand jury declines to indict. And so the court has said, we are going to allow them to represent to the grand jury because there's no other avenue for error correction in case that first grand jury got it wrong. But the court has also said, more than that would require some judicial oversight. But I think the main point I want to make is that the Commonwealth isn't really harmed by holding us to the rule that the magistrate's decision must be obeyed. We don't want the Commonwealth to have an incentive to refile the same application to a different clerk magistrate, to wait 2 or 3 years.
That's a little weird to me because I think if there's no deadline on filing the 211-3 or seeking redetermination by a district court judge, then they are being harmed because it's basically a procedural choice. They decided to go back and start afresh rather than seeking appellate review, which they could have done at the same time since there was no time limit.
I
So
think that
it
the
feels-
legislature has indicated that the defendant in that statute, 218, Section 35, has indicated that there is a time limit beyond which a defendant does have a finality interest that is vested in a decision that says, you're done, you don't have to be prosecuted.
Okay, I'm going to just ask Justice Stewart if you still wanted to ask a question.
Just briefly, did you want to address the ruling of the trial court that the due process claim failed because the defendant had not shown harm from the 3-year delay? The judge acknowledged that the 3-year delay was lengthy, but fell within the statute of limitations. And did you want to address that point?
Well, I would say that, our due process argument is tied to our collateral estoppel argument, and collateral estoppel doesn't require a finding of prejudice other than the prejudice inherent in having being brought back into court to relitigate an issue that's already been litigated. If this case goes back to the trial court and we do not prevail here, I think we would have a basis to seek further relief for pre-indictment, for delay that would require an evidentiary hearing where both sides would be able to present evidence on the prejudice question.
Under Rule 36, correct? The last part of Rule 36, you could bring the delay claim, right?
I believe we'd have that issue, yes,
Right.
Your Honor.
Okay, thank you.
Thank you.
Okay, Attorney Lynch.
Morning, may it please the court. Travis Lynch for the Commonwealth, asking that the 211-3 petition in this case be denied. There's the threshold question about whether 211-3 or these claims are even reviewable under 211-3, which we haven't talked about yet today. And in our view, the claims aren't reviewable under Chapter 211, Section 3 in this interlocutory posture because they're not the functional equivalent of a right not to be tried. Because fundamentally, even if there's some problem with the district court proceedings, the Commonwealth could just get an indictment. So just like the NM case, the claim really is maybe, at best for them, I have a right not to be proceeded against in district court by a complaint. But that type of claim doesn't get through on 211-3. And I understand that it's reserved and reported by the single justice.
Where's the remedy for the Commonwealth's negligence? At least in this case.
Well, I think the defendant would need to show some concrete prejudice from that. If
You would concede the prosecution was negligent in this case, right?
I would certainly say that it wasn't best practice to wait this long, and I agree that,
Well, not appealing.
well, we don't have to do that. That's not a necessary part of the process, but. I mean,
But you can't wait until the defendant asks for his firearm back and then go back to refile, right? I mean, there is something untoward about that.
Well, I would say that that's based on a one-sided affidavit.
Well, that's
from
what
the
we have, yeah.
That's what the defendant says. We didn't agree to those facts. That's not part of the agreed
The
statement.
timeline, though, is odd.
I mean, it is odd. I mean, you can't run from that. I mean, certainly in 7 years in the BMC, I'd never seen this, right? I mean, you don't get PC, you appeal to the judge. That's the standard operating procedure. So there's something odd about here. Whether there's something unlawful is another question.
Sure, it might be odd, but I don't think that it's unlawful not to use the optional district court practice manual option. It's an option. It's not something that's mandatory. It's not even a statutorily created process.
It's not, but as to the term untoward, it does feel like it's shopping, right? And that's one of the things that certainly as a judicial officer, you're not going to countenance, that folks are not getting probable cause or either finding a more favorable assistant clerk magistrate or waiting for, the preferred judge in the first session to take the appeal. We can't be part and parcel of that.
Well, I think, right, but that's not a collateral estoppel issue.
Right, so why don't we turn to the merits?
Okay. So,
So on the collateral estoppel issue, what's the rationale for allowing the Commonwealth to if they fail in the district court to establish probable cause for whatever reason, and then allowing the Commonwealth then to go convene a grand jury to seek an indictment?
so the old bind over cases. So, to be honest with you, I'm not exactly sure what the rationale for
But
that
isn't that
is.
important why in our jurisprudence we allow the Commonwealth to go convene a grand jury when they fail to establish probable cause?
I mean,
For this case.
the Commonwealth can always choose to proceed by way of indictment in the Superior Court because that's the court that has general jurisdiction over criminal offenses. But
that's not responsive. I'm wondering what the rationale is for if at first you don't succeed in the district court, you can go convene a grand jury.
Well, in Burke, didn't the court say that the reason why you can go to the grand jury after no bind over was because there's no appellate right?
right, you're right, there is no appellate right.
Right,
Right.
which is the opposite of what happens here. There is an appellate right.
Well, I would say
Well, there's not a statutory appellate right, but there's a means of appeal.
there is a means to obtain some degree of review, but I would submit that it's not truly an appeal. I think the court.
So if the rationale is that you didn't have an appellate right under Burke, and here you do have an appellate option, what's the rationale for allowing the Commonwealth to do what it has done in this case?
Because that's not really a statutorily created process.
So you
And
think
all-
under Burke, you need a statute that tells you can appeal, and it's not enough that we have in our jurisprudence created a 35A appeal?
I think the court recognizes a 35A appeal. I think in Bradford against Knights, it talks about how it was a practice of the district court that the court describes. But one of the things that I would point out is in, I believe, Boston Globe Partners, the court says it's not really an appeal. It's an appeal in scare quotes because the judge doesn't actually have to pass on the merits. The judge can do whatever they want with the appeal. It's not really an appeal in the sense that the higher court has to review the merits. So it's not truly an appeal.
So, but I guess I'm trying to figure out why the Commonwealth doesn't have to at least try to activate that avenue of appeal, which you call a faux appeal. And if it becomes not a real appeal, then maybe you can go seek an indictment or retry again. But why don't you have to at least try that appellate process? If the rationale for allowing option B to be triggered when option A doesn't work is the lack of an appeal.
Again, I mean, I don't want to not answer your question, but again, I would say it's not really an appeal. That's my answer to that.
So you don't have to even try it.
You don't have to, no. There's nothing that says that we have to. It's not a statutorily created process. It's similar, I mean, in the grand jury context, the rationale for allowing us to present the same case to a second grand jury is there's no statute that says we can't take that approach. And at least in this case.
It's not because you can't appeal the failure of the grand jury to indict?
It's because the legislature hasn't created a limitation. And at least on the facts of that McCravey case, the court declined to create a limitation, at least in the situation where it's only 2 presentations. And here, we've only done 2 presentations, or sorry, the police department did 2 presentations.
I have a question about that. I mean, are you really suggesting that the police didn't cooperate with the ADA in seeking this application and the decision on whether or not to appeal the first one? Because it seems like the record was pretty clear that Officer Veit
I believe that's right.
was cooperating with the ADA, got bad advice maybe from the first ADA and then reconvened with the second ADA and got more advice.
So,
I mean, this wasn't an application by the officer individually. It was in his official capacity in cooperation with the ADA, right?
I don't know if the record is that clear as to what the ADA's role was at the when the initial complaint was applied for. I don't know if the record is that clear. But as the judge said, as the lower court, the experienced district court judge says, as a practical matter, the district attorney doesn't usually actually appear at these show cause hearings. And that's one of the factors to consider in whether there's neutrality of parties, which is another necessary element of collateral estoppel.
Do you think that there's a problem with the defendant's collateral estoppel case because this is really a legal issue as opposed to a factual issue that's been determined by anybody? Or whether this particular crime requires the motor vehicle or not?
I'm not sure the answer to your question, respectfully.
Okay, that's fair.
But as a matter of due process, the clerk magistrate obviously got it wrong in this case. The magistrate said you need a motor vehicle, you need to be in a motor vehicle basically to commit this crime. The plain text seems to say if you're carrying a firearm while intoxicated, a loaded firearm while intoxicated, or you have it under your control in a motor vehicle. It's an either or. And in this case, the complaint application shows the defendant is intoxicated while having a gun on his person. So to the extent that there's a due process concern here in the abstract, I think it's significantly lessened in this case given the nature of the magistrate's first denial, because the first magistrate just didn't understand the statute. It's not as if she discredited the police officers at the first hearing. She didn't make a negative credibility call against them, which I suppose theoretically is a possible way for her to have denied the complaint. But it seems as though it's a legal error that was the basis for her denial. And on a level of due process, I would say where the first decision was clearly wrong, there's just no basis to say we can't get a complaint now.
Well, you're speculating, right, when you say that the clerk magistrate didn't discredit the police officers, correct?
Well, I would
Because the clerk,
inference, respectfully.
you're drawing an inference, but the clerk magistrate could have listened to the police officers, or police officer, I think it was singular, and said, and thought to herself, I don't believe this, and then just written down, said like, you haven't met the requirements of the statute, just to be polite or something. We'd have no idea we don't have a written decision, we don't know, correct? Like the notation on the docket is not a written decision, is it, or is it?
Well, that's the closest thing we have to a decision on the merits in this case. And the only thing we have to go on is her misinterpretation of the statute. But all of what you just said would also tend to suggest is not really a fully reasoned decision, which would also weigh against it having collateral estoppel effect. Not a fully reasoned decision, which I would say robs it of any finality value that it might have.
What prong of collateral estoppel is that?
Well, if you get a 25B determination by a judge, they make the wrong call and not fully reasoned, you still have a problem, right?
Well, that's a double jeopardy problem.
Right.
There's no jeopardy in this case.
Your criteria of fully reasoned.
Right, but the Commonwealth also can't do anything about that, and we have no right of appeal from that decision, and we're just out because of double jeopardy. But double jeopardy is different from collateral estoppel.
Right, I get that.
Right. This is not a double jeopardy case, obviously. So at least where, to date, the Commonwealth can present the same case to two different grand juries, and that's still good law, and at least on this fact pattern where the magistrate denied the complaint application because she didn't understand the statute, there's no due process issue in this case. And I don't think that the court needs to go any further than the facts of this case.
Have you looked for any records from that first clerk magistrate's decision?
I have not, and it's been represented that they don't exist anymore.
Is that because of the one-year destruction deadline?
I infer that that's the case, but I honestly don't.
What do we do about that?
The fact that we don't have a record from that.
How does that weigh in the collateral estoppel analysis, if at all?
I don't think it does because, I mean, the district court is following a statutory procedure for record retention. I don't think that, at least where the statute of limitations for this offense is 6 years, I don't see why an interaction between that record retention statute and the statute of limitation does anything. We're clearly...
Can you address counsel's argument that the statute of limitations protects the interest in when prosecution can be commenced as opposed to, any sort of vested finality interest that the defendant may have in the first decision?
Well, given that the legislature has said that the general statute of limitations is 6 years, I would say that the defendant's reliance on a 1-year, essentially, statute of limitations is misplaced. The legislature has made a policy judgment that the Commonwealth gets to start a criminal prosecution 6 years after the incident. So,
But what do we do with the fact that the Commonwealth tried to start within the 6 years? How many at-bats does the Commonwealth get?
I don't think you need to go further than saying we get at least 2, which is what the court also did in McCravey.
The delay in this case, when we started talking about how the government hasn't covered itself in glory, at the very end of counsel's argument, she mentioned dismissal under Rule 36, correct? The last part of Rule 36 for delay.
Yes, she talked about that.
Right. So that would be a means to vindicate the defendant's interest in delay here, right? Or punish the Commonwealth for unreasonable delay?
There's a constitutional...
There's a dismissal.
Well, there's not, I don't think Rule 30, are you talking about non-prejudice-based Rule 36?
Right.
Well, there's never a return date, so...
Well, there's timeliness under Rule 36 of bringing charges when you know the charges, correct?
I believe you're right. But...
Let's assume I am.
Sure.
All right. That would be a way to vindicate the defendant's interest in this unreasonable delay, correct?
It's possible, yes. But that's not the issue that's here right now. Unless there's any further questions, I'd ask the petition be denied.
Okay.
Thank you.